Hello again. All right, now we are moving on to what I have as handout for, it might be called note for on Blackboard, but it is basically a description of different elements that have to do with personal property and how it is conveyed, transferred, handled, shown, ownership, all those good things. We'll start off with the idea of a gift. A gift is a present transfer of property from one person to another with the intent that the receiver become the owner of the property. The giver is called the donor or donor, and the receiver is called the donee. So a donor is a person who makes a gift of property. A donee is a person who receives a gift of property. By definition, there is no consideration for a gift. There is no exchange. So you have one side that has complete ownership of the property, and what they're doing is they're taking that ownership and they're transferring it to the other side, to the donee. Now, there are a couple of different categories of gifts. One is called a gift causa mortis, and that's Latin for because of death. If you feel that death is imminent and you make a gift, Fred, I'm not going to recover from this illness. I want you to have my father's silver pocket watch. And you give it to Fred. Fred happily accepts it. But then you survive, you recover. The law says in that situation, the gift was a conditional gift. It was made on the condition that you not survive. And by virtue of the fact that you have survived, the gift is now null and void. And when you demand to get the watch back from Fred, you can do that. And if he refuses to give it to you, you can go to court and force him to return the watch. An inter vivos gift means a gift during life, during the fullness of life, and it is final. So upon delivery of the gift to the donee, the donor has no power, no right to take it back. Ownership has transferred. The donee is now the owner. And if they chose to gift it back to you, they could, but they do not have to. And even if you go to court, you cannot use the law to require them to give the item back to you. Now, there are elements to making a gift, just as there are elements to almost every definition, every process in the law. The elements to making a gift include, number one, the intention. The owner, who has the property, who is the owner of the property, has to intend that this be a gift. So if we are sitting in class waiting for it to begin one night, and I say to you, here, hold my textbook while I go down to the cafeteria to grab a cup of coffee. Even though I've given you possession of the textbook, and by my words I've indicated I want you to hold it, I have not made a gift, because my words there, my actions would indicate that when I come back, I intend to have the book returned to me, that I'm just basically giving you possession of it for a while for a particular purpose, and then I would get it back. So we always have to know that there is intention, and now intention can be expressed, stated, I hereby make a gift to you, or it can be implied. I put a $100 bill in a birthday card, and I send it off to my friend, and I write happy birthday with the $100 bill stuck inside the card in the envelope. Even though I haven't said anything, because of the social understanding of what's going on in that transaction, the implication would be that the $100 was a gift, and I show up next week and say, I just sent that $100 for you to hold. I really need it. Can you give it back? They'd have every right to say, no, that was a gift. You sent it to me for my birthday. I had every right to believe it was a gift, so therefore it is final. There must be delivery of the gift. And delivery can be constructive or it can be actual. Actual delivery is when you take possession of the item and you hand it to the person and say, here it is. So I take the $100 bill, I'm in your presence, I hand it to you and say, happy birthday, here's a present. I hand the $100 bill over to you. That is a gift. There is intention shown by my words about it being your birthday, and there is delivery by handing it to you. Now, constructive delivery is when you can't hand the item over per se, but you somehow make it so that the donee can obtain possession. If I had left things in a safe deposit box, and I put the donee's name on the box with mine, and I give them the key and say, hi, there's some money in the safe deposit box at First Bank, go down and get it when you can. By giving the key, some would argue that I have given constructive possession to the donee and that they are there for the owner. Certainly, if I'm giving my daughter a car for her birthday, I don't have to drag the car into the house. I can hand her the keys to the car and say, here, happy birthday. And by doing that, by handing her the keys, I've given her the ability to possess and control the car. It would be hers. We're going to find out in a little bit. Cars also have title certificates that muck that up a little bit, but that's the general idea. There has to be acceptance. And again, the acceptance has to be constructive or actual. Actual acceptance is where you say, thank you, I'll take it. Where the donee takes possession of the item, the donee begins to use the item. That is actual acceptance. Constructive acceptance would be where you may not have expressly stated your wishes that, yes, I accept, but somehow you start to exercise control over the item, start to tell other people that, oh, yes, my aunt gave me such and such for my birthday. Then we would say that you have a completed gift. So the three items that we need are intention to make the gift on the part of the donor, delivery of the gift from the donor to the donee, and acceptance by the donee. All right. Now, there's always been an issue in the law, and the states still are not clear at this point on it, although there seems to be a general direction here, as what happens with an engagement ring. When somebody, and I suppose today it could be a woman giving it to the man or the man giving it to the woman. Traditionally, it was the man giving a diamond or some other type of valuable ring to the woman. What happens if the marriage does not occur? Now, this gets tricky because there are two aspects to this. Certainly, giving the ring to your significant other would be an indication of making a gift. Wouldn't necessarily need words, just by actions it might be. However, marriage, in its truest sense, has an element of contractual relationship to it. And particularly if you went back into the older times before 1900, very often marriages were arranged. Marriages were not just to put these two people together. They had nothing to do with love or intimacy or that, oh, I want to marry that person, but marriages were arranged by families, and there were property rights that were exchanged as part of the marriage. There was actually a marriage contract, and there would be dowries that the woman's family would have to put up, and there'd be other properties and items that would come from the groom's family to the wife's family. So there was a contractual nature to this, and for many years, a number of courts ruled that giving of an engagement ring prior to marriage is part of the contractual basis of the marriage. So if the marriage does not happen, the contract is now null and void, and the ring would have to go back to whoever was the donor. To modify that a bit, a number of states have looked at it and said, if the ring were given at Christmas, on a birthday, on an anniversary of meeting or some other type thing, then they would tend to look at it as a gift, that it wasn't being given just as part of the eventual marriage contract as one of the terms of proceeding into the marriage, but that it would actually be a gift. So I suppose the story here is, if you are giving a ring to your significant other, make sure you do it at a time when it's not their birthday, it's not an anniversary, it's not their graduation, it's not Christmas or New Year's. And then you could claim that I was giving it only hoping that we would get married, and if we don't get married, I want it back. So if you give it to them on one of the occasions where you would normally give a gift to someone and make it final, you run the great risk that the court is going to say giving of the engagement ring was a final gift. Now, another way that we deal with transfer of ownership of personal property is through what we call sales. And actually, in our consumer society, the vast amount of personal property is exchanged by way of sale. And sale is merely a situation where we transfer the ownership of property for consideration. And again, that can be expressed with stated terms, or it can be implied by action, by activity. It can be, now, what's happening here, when we have a sale, we are in effect making a contract. And so you have to think it through. If you walk into CVS, you want to buy a package of gum, it's in that little display case right at the register. You walk up to the register, you grab a package of gum, you get in line, and then you plop down on the counter a $10 bill and the package of gum. You may never have to say a word. The clerk picks it up, runs it through the register, gives you change, your package of gum, a sales receipt, and a little bag, and off you go. What has happened there is a sale. Ownership of the gum, which is personal property, is transferred from CVS to you, but there's also been a contract created, and it was completely implied. You never had to say a word, just by your actions. All right, picking up the gum, putting it on the counter with the money is an indication that you wish to buy this item. The prices are listed on the items at this point in time, so you know what it is. CVS, the clerk, by picking up the money and running it through the register and making change, is indicating that they accept their end of the deal. And we have offered acceptance, we have consideration, we have an agreement. It's legal. CVS has capacity. You have capacity. There is no fraud here. We have a contract, and what's happened is that contract results in change of ownership of that package of gum from CVS to you. And if you think about it, almost every consumer transaction takes place in sort of the same way. Certainly with ones involving a lot more money, buying several $1,000 piece of furniture, or having a several $100 suit made or outfit made or whatever, there'll be more paperwork involved. There may actually be signed agreements setting out the contract. But the reality is the sale is a contract, and the result of that contract is there's an exchange of value, at the end of which ownership of the good has switched from one party to the other. As part of this, one of the things that happens in our society is that you'll have a big box store, and let's say they're selling widescreen TVs, 54-inch screen TVs. Very often, they will get those TVs from the manufacturer, and they will not pay for them. And in fact, they have a deal with the manufacturer where they will hold the TVs and sell them. They pay the manufacturer so much for each one that's sold, and at the end of a certain period of time, any that haven't sold are sent back to the manufacturer or otherwise disposed of at the manufacturer's instructions, which is one of the reasons why places like Ocean State Job Lot exist. They pick up this merchandise that hasn't been sold in the first market, and they take it and they pay a certain price for it and they resell it. When we're dealing with expensive items, it may not even be inexpensive items, because many supermarkets operate this way with their chip aisle, their bread aisle. The bread and the chips that are there are not owned by the market. The market basically grants the companies that manufacture the product shelf space. They agree to collect the money, and then after items are sold, they will pay a certain percentage of the money to the manufacturer, and they will keep a certain percentage for their having displayed it and having allowed their shelves in their store to be used. But if the expiration date comes and things haven't been sold, the company's required to come in and remove all those expired products and not leave them there in the store. So what happens in these situations is ownership is still very often held by the original manufacturer. Or at the very least, the manufacturer has a lien, which says, if you don't pay me for all those TVs, we take back whichever ones you haven't paid for. To put it simply, those types of liens, and certainly the ownership, is an issue for a third party now buying. So you go into a big box store, you're going to put down a couple $1,000s for this huge TV, and in reality, the TV manufacturer in Tokyo is still the actual owner of that TV. what happens if Box Store doesn't pay the manufacturer? Can they come to your house, show up one night, and everything now has computerized serial numbers? It's very easy to keep track of all these things on big ticket items. They show up at your house and say, oh, sorry, but Big Box Store didn't pay us for that TV set. We want it back. That doesn't happen, and legally it can't happen because there's something called the bona fide purchaser rule. Now, bona fides is just a Latin term for good faith. So you can think of this as a good faith purchaser rule. And what the good faith purchaser rule says, that if you go into a store, into an establishment, into a regular place of business, and you are taking a piece of property for consideration, for value, without any notice or knowledge that the seller is not the owner and does not have the right to give it to you, you become the owner of the property. And then it is between the store owner and the manufacturer to figure out what's going on after that. But you have walked away and you have become the owner of the property, even though the store may not have been the actual owner. A very important concept, because otherwise we'd have to trace, just like we do with land. When we get into land sales, we find out that we do title exams, go back a number of years to make sure that all the transactions have been in order and people really had the authority and the ability to convey good title. We'd have to do that for every piece of personal property. Of course, the paperwork that will create would be nearly impossible up to this point. Although I look at Amazon, particularly what's been going on through COVID-19, and their computer systems are getting very close to the point where we may be able to track the history of a bar of soap from the manufacturer through the various distributors to the final customer in the not too distant future. But traditionally, that type of paperwork would have just been far too expensive, far too burdensome. Nobody had the ability to do it, to store it, to keep track of it. So this system was devised whereby the ultimate seller, so long as they were acting in good faith, they would be protected. Now, I usually would tell my students, I usually wear my jacket for this lecture, my suit jacket, and tell them the story of when I was a law student in Boston. Suffolk University is located right downtown. I would have to go down to the Park Street subway station, which is a massive subway station, and at 5 o'clock at night, it's absolutely incredibly busy, packed with people, and there would be people standing there, and they'd open their coat, and they'd have 15 or 20 Rolexes pinned inside their coat, and they'd be like, hey, you want a watch? Really good watch, real Rolex, anyone, $25, come on, hurry up before the cops come. That is not a good faith transaction. There is reason to believe that there's something suspicious, such as they're either ripoffs or they are stolen, that somebody buying in that situation could not claim to be a bona fide purchaser. However, when you walk into a store, when you walk into a regular commercial establishment, you have no reason to believe that you're not getting good title when you buy something and bring it out. So and as long as you're paying decent value for it, even if it's on sale, but still you have to come up with some consideration for it, then you can be considered a bona fide purchaser. One of the other situations that comes up here, an example I give that today, it's getting further and further away from this type of stuff, so it's probably harder for you people to understand, but for years, watches were mechanical, not electronic, not digital, and as mechanical pieces, they would break down. Parts would break, they would not work, they would get out unaligned inside, they wouldn't work correctly, and there were places that were watch repair shops. Very often jewelry stores would sell fine watches, which could be very expensive, and at the same time they would also repair them. And so it would not be unusual, if we went back 40, 50 years ago, that somebody had a high quality watch, it wasn't working correctly, and they would bring it to a jeweler or to a watch shop and say, here, my watch isn't working, can I leave it with you, can you try to fix it, whatever, and they would leave this very valuable watch and walk out with a little ticket, almost like you get from the dry cleaner, saying, oh yes, you have the right to come back and get the watch. Now, many of these places sold new and used items. Many of these watches were particularly valuable to the point where even as a used item, they had resale value. And certain watches, just like with certain cars and other items, as they got older, actually became more valuable as they became rarer and rarer. And one of the scenarios that I use is to say, Harry had a gold pocket watch he inherited from his grandfather, had been in his family for 100 years. It wasn't working right. He brings it into the repair shop to be repaired. They give him a ticket, but it's really busy, and they forget to put a ticket on the watch saying that it's a repair. And instead, they end up putting it in the tray with the used watches. Somebody comes in a couple of days later, buys the watch, pays what's considered full price for the used watch, and leaves. Now, luckily, the shop keeps very good records. Other than this one time they made the mistake, Harry comes back and says, okay, where's my grandfather's watch? I haven't heard from you. What's going on? They run through all their records and they realize that Fred Smith bought it 4 days ago and walked off with it. But they have Fred's number and address. They call Fred. Fred says, well, I love this watch. I'm not giving it back. In this situation, I think Harry might be out of luck. Because again, Fred walked into a watch shop that as its regular business sells used watches and new watches. He found a used watch that struck his fancy. He paid money for it, and he left with it without any idea, without any possible knowledge or notice that there was something wrong with the title, that the watch shop didn't really own it. I think he would win a lawsuit if Harry sued him to try and get the watch back. Now, Harry has the right to sue the watch company for mishandling his goods, and will probably collect a decent sum of money and might even be able to claim pain and suffering as a consequential damage here. But I'm not sure that he would be able to get back the watch unless Fred was a gentleman and was willing to sell it back to him or sell it back to the store. So it's just something to consider, and really part of what goes on here, the law looks at, well, who's the innocent bystander in this, and who had the most control over the situation and fixing it. And here, Harry picked this watch shop. This watch shop was in the business. They're the ones who should have had more control of the situation. Fred is an innocent third party walking into this mess. The same thing if the manufacturer of the TV set and the big box store get into a financial brouhaha with each other, claim they owe each other money and whatever. There's no way the consumer can know what's going on there. The really innocent party is the consumer, and the consumers shouldn't be subject to what's going on between these other two folks who decided to do business with each other, and then it went south, it went bad. So just be aware of that. As you send things out to be repaired and be taken care of, just be aware that these types of things do and they can happen. And there are rules to be applied when they happen. A bailment is a situation where the owner of property gives possession of the property to another person for a specific purpose or for a period of time. And this, of course, is done permissively. The person who owns the property can't be forced to do this. They're doing this by their permission, by their consent. When you bring your clothes to the dry cleaners to be cleaned, you are, in effect, creating a bailment. You own the clothes. You're bringing them into the dry cleaners. You're leaving them with the dry cleaner for a specific purpose, which is a contract. They're going to clean your clothes. You're going to pay them for cleaning your clothes. And at the end of this, when your clothes have been cleaned and you pay for the cleaning service, they will hand your clothes, now clean clothes, back to you. The process is called a bailment. And it's interesting because we usually think of bail in criminal law, and it does come from the same Old English root. Bail means to have possession, to grab. So the bailee in the jail had your body, and you had to pay bail to get yourself out. And here we're talking about possession of the piece. Who has possession of the piece of personal property? The person who owns the property and gives it up is the bailor. The person who receives it for the purpose is the bailee. Now, very often in commercial situations, these are contracts. So here the contract was to get the clothes cleaned and to pay money for it. But they can also be social situations. Your friend has a real a date. I'm using old ideas here. How can we change this? Your friend wants to drive down to Cape May, New Jersey for a few days, and his car is really in tough shape, may not make it across the Jersey Turnpike and the George Washington Bridge. So you decide to let him borrow your very new, just year-old car, expensive car, to take and use for a few days and then bring it back. That is still a bailment, even though there's no contract there. That's a social bailment. And there are certain rights and responsibilities and duties that go along with that. Now, what happens if the item is damaged or destroyed? Bailees the people who receive the property have certain liabilities. If the bailee is benefiting from the possession of the property, they owe a high degree of care. So when you let your friend take your car for free for a weekend, they owe a high degree of care to you. If the bailee is not benefiting from possession, you're going away for 3 weeks and you need somebody to take care of your Great Dane, you can't leave him in the apartment for the 3 weeks alone, and your friend begrudgingly agrees to take the dog and take care of it. The dog is pets, I hate to tell you, even though we love them and we think of them as our siblings sometimes, they are our children, they are chattel, they are personal property. And you get your friend to take care of the dog for you while you're gone. The friend only owes a slight duty of care to the dog because the friend is not getting anything out of this. They're doing you a favor, they're doing something for you. If the arrangement is a commercial arrangement and the parties are in equal settings, such as I leave my shirts at the laundry to be cleaned and the laundry's paid for the service, the bailee, the laundry has a reasonable degree of care that they need to take and to apply to the situation. A word to the wise, one of the questions I love to put on the quizzes has to do with valet parking. Prior to COVID and all the ramifications of that, my wife and I love to go out to eat, as you can probably tell from looking at me. And one of the places, being Rhode Islanders, we love to go was Atwells Avenue, Federal Hill. The thing I hated about Federal Hill, at least in the early years of the restaurants beginning to bloom there, was that you can never find a place to park. And I can remember parking blocks away in the bowels of Federal Hill or way down by the railroad tracks or whatever and having to hike back to the restaurant. Well, the restaurateurs realized that this was a drain on their business, that people are not happy with the parking situation. So prior to COVID, for the last few years, every establishment, particularly on a Friday or a Saturday night, they had valet parking, which is wonderful. You drive up to the door of your favorite restaurant, you hand some kid your keys, they give you a little piece of cardboard, you walk in, you have dinner, you don't think about anything, and then when you walk out, you hand $5 in the cardboard to the kid and they come back with your car. Wonderful scenario. It is a bailment. You are giving your personal property, your automobile, to a third party for a particular purpose, which in this case is actually a contract, because there is a service being exchanged for money. Now, even if the valet parking is free, the exchange of value has to do with, that's part of what you're paying to go in and pay the high prices for this meal in this restaurant, is that not only are they giving you food and alcohol and a nice atmosphere in which to eat and drink, they are taking care of your car while you do it. So in effect, part of the contractual arrangement you have with the restaurateur is that they will take care of your car. But what happens if your car comes back with one side smashed in? Who is responsible? Who are these kids with the keys? Are they employees of the restaurants? Looking at the little blue tags I had gotten over the years, I come to understand that there are one or two valet services that contract with the restaurants to provide the service. So it's not even the restaurant's employee that's doing this for you. It's a third party that's been contracted by the restaurant to do it. And of course, everybody said, well, on the back of the tag, there's a thing saying they're not responsible for anything. That may or may not be valid. Usually in these types of situations, that disclaimer is not valid. It's just there to hopefully keep some people from suing. So the question becomes now, the car comes back, it's damaged, and you say to the kid, look at my car, what happened? He says to you, it wasn't like that when you dropped it off? You're like, no, it wasn't. You can complain to the restaurateur. The restaurateur is going to come out and say, I don't know what's going on. I have nothing to do with this. You can have the kid's boss come down, who can say to the kid, did you smash the car? He goes, no, I didn't smash it. I think it was like that when they dropped. What's going to happen? Whose insurance pays? Who's going to cover this? Interesting question. All right, and I'm not sure that I have an exact answer. There are several layers of responsibility and several layers of liability here. This is a question I love to ask when I teach torts as well, because there was damage caused somehow, and somebody needs to be responsible for it. Somebody's going to get stuck with the bill for it. The question becomes who it is. I would venture to say, in my estimation, it would probably be the valet company, because part of their implied promise is that they are going to keep your car safe and that you don't have to worry about it while they have it in their possession. So even though they didn't say it in those words, the whole point of doing the valet service is that. And even though you're not paying them directly, the restaurateur would be paying for their services. They still owe you a duty of care as a third-party beneficiary of the contract between them and the restaurant. So, but I think you can see, just in simple everyday examples, how some of this can get very, very complicated very, very quickly. Also, I would advise you tip them $10. If they get used to seeing $10 from you, your car will be taken care of extremely well all the time. Don't just leave them $5. I almost died one night. I was with one of my associates, and he went to hand the kid $2, which I quickly pulled out a 10, stuck that in the kid's hands with it, and just shook my head and said, he's from New York, he doesn't know what's going on here, which he wasn't. But it was just, you pay those people what they need, what they deserve, and for taking care of your car for a few hours, they deserve more than $1 or $2 or even $5, I think, in this society. All right, one of the things about bailments, too, has to do with who has the burden of proof in court. Now, those of you who are paralegal students, if you've talked at all about litigation, how it works, if my car is damaged and nobody's willing to pick up the damage and pay for it and admit that it's wrong, either I or my insurance company are going to end up suing the restaurant, suing the valet company, trying to get back money to recoup for the damages. Normally, when you file a lawsuit, you must have the evidence. You have the duty to go forward, to produce evidence. And if you can't produce a certain amount of evidence as to what happens, you can be dismissed before the other side ever has to say a word. They can bring a motion to dismiss on the grounds that you failed to make a claim, to state a claim. Bring a motion for summary judgment. In bailments, the law reverses that duty so that the bailee actually has the duty. So my car has been damaged. I'm the bailor. I'm suing. However, I have no idea what went on because the car was not in my possession. In these situations, in one of the few places in all of English American law, we reverse that burden of proof. And we now say, all right, Mr. Bailey, you were in sole possession of the car. You must be able to tell us why you were not negligent, or we are going to presume that you were negligent, and we're going to proceed otherwise, and Mr. Walsh doesn't need to bring in proof of your negligence because there's no way he could do that. He wasn't present, he wasn't there, he didn't see what happened. By nature of the transaction, only you, the bailee, has the key to what went on by either seeing it or knowing it or whatever at the time. So just a little side thing there for those of you who are studying litigation, talking about burdens of proof, who has to go first, who has to go second in the lawsuit. And there are very definite rules about that. And normally the person bringing the case has to have enough factual evidence to present what we call a prima first face case. That can be done by way of affidavits and submission of items of evidence. But if you cannot do that before you ever get to a jury, before you ever get into a courtroom for an actual hearing with witnesses and that, the other side can bring a motion for summary judgment saying, Your Honor, they don't have anything here. They're wasting the court's time. And if you can't establish that you have something, then you will be dismissed, and dismissed with prejudice usually, so that you cannot bring the case again. Okay. Bank accounts create a whole nasty reality. Bank accounts are contracts. You give your cash to the bank. They agree to give it back to you with a certain amount of almost nothing interest. And you have this contractual relationship with them. And the relationship is evidenced usually by an account where every month or every quarter they send you a statement. Here's how much money is we're obligated to give back to you when you come to ask for it. It goes on like that. But one of the things about accounts is accounts can have, as with any type of property, but particularly bank accounts, can have the names of more than one person on them. Now, the issue then becomes, if I go into the bank and I open up an account and I put my nephew's name on it, who's the owner of that account? And I'm the only one. I put money in, I take money out, I use it, then I die. Does that account go to my estate? Does that account go to my nephew? My will doesn't leave anything to my nephew. It leaves it to my children. Do they get the bank account, or does my nephew? Years ago, these types of bank accounts were called Totten Trusts, named after a lawsuit where a family named Totten was involved. And they were looked upon as poor man's estate planning, where you didn't have enough money to hire a lawyer to write a will, to set up a trust, that you would put money in the bank and put different people's names on it. And then when you died, the expectation was that money would go to them. The courts did not like those at first, but they gradually came to accept them. But then there was also another theory developed, something called a convenience account. And a convenience account exists in a situation where, and I have to go back to my ethnic roots of 60-some years ago, when I was growing up. I'm Irish, growing up in an Irish neighborhood, and many of the families had 4, 5, 6, 7 children. And the reality of life was that the oldest children very often got sent out to work as soon as they graduated high school, or even earlier sometimes, because the family needed money. A couple of the middle children might be sent off, if they were Catholic, to be priests or a nun, to get your afterlife taken care of. And then somewhere along the way, one of the children, usually a daughter, very often the oldest daughter, if she was first in line, would end up never marrying, end up staying with the parents, living with the parents all their lives, taking care of them. And then the parents eventually would pass away. And we now have a situation, the parents, they left the house, they left money in the bank, they left some cars, other stuff, and they've got 7 children, but Mary spent her entire life taking care of her parents. Now, I know in Irish families, it was very often declared by the parents that because Mary took care of us, she's getting the house. We put her name on the house, and you better damn well not contest that or fight that, because that's what's supposed to happen. And very often, if there was any money left in the parents' names, a big chunk of that would go to Mary too, in exchange for her not having had a life that her brothers and sisters were able to have. But the issue becomes, Mom and Mary have lived together all their lives. Mom gets to be 90, Mary's 67, 68. Mom's having trouble seeing, she's having trouble writing, she's got a little bit of the tremors that go on at that age with many people. And so she says to Mary, I'm finally ready, I'm going to put your name on the bank account so you can write the checks for me every month, because I just can't do it anymore. So they go down to the bank, they add Mary's name to the bank account with $200,000 in it. Mary writes checks for Mom for a few months, and then Mom passes away with $198,000 left in the account still. And Mary now says to her brothers and sisters, Mom put my name on that account, that's my money. For many years, the courts would entertain a lawsuit by the siblings saying that if they could prove that that account was set up for convenience, only so that Mary could act as a pseudo power of attorney in fact for Mom, to help her pay bills, help her write accounts, and then that money would have to go into Mom's estate and be divided among all the children. It wouldn't be just Mary's. If they couldn't prove that, then by virtue of most of the banking agreements, the fact that Mary's name was on it, when Mom died, Mary would become the owner. This was a very fertile ground for lawsuits, and the courts were jammed up with these types of lawsuits. The judges got sick of hearing them, I think, and about 5 years ago now, the Rhode Island Supreme Court finally came down with a case where they said they basically did away with the idea of convenience accounts and says whatever is on the bank paperwork. If the bank paperwork says Mary is the survivor, Mary is a beneficiary, Mary is a co-owner, then we're presuming that in this day and age, the majority of our citizens know how to read and write. They know what co-ownership means. They know what survivorship means. And therefore, whether they intended it or not, if they put that on the bank documents or they let the bank documents go through that way, then that's what the account is. And we don't care what anyone else, any other heirs or family members say. We are done with playing these games. So just beware at this point. Massachusetts has not, they were never as much into allowing the convenience accounts as Rhode Island was, but they have not curtailed them as much either. So in Rhode Island, basically at this point, if you put someone else's name on your bank account, they are going to get that money when you die. And even if you intended something else to happen, unless they're nice folks and voluntarily make gifts of this money that you left to them, to the people you wanted it to go to, it's going to them, and they're going to have every legal right to keep it. All right. Property that's lost. The definition of lost property is that it's property that has become separated from its owner, and the longer in time and the further away it gets from the owner, the less likelihood that the owner is ever going to be able to retrieve it or discover it, or if somebody finds it, that the true owner would be found. But the reality is, when you lose a piece of property, you have not given up your ownership rights. All right? And this is different from abandoned property. When you get sick of that chair in the living room and you stick it out on the sidewalk on trash day, the minute you put it on the sidewalk, you have abandoned it. So one of the junk collectors can drive by their pickup truck, look at it and say, oh, that looks like a nice chair, pick it up. And you almost can't stop them at that point, because by virtue of putting it out on the trash, on trash day, you have indicated you no longer wish to be the owner of that property. You have given up possession of it by putting it on the sidewalk that you don't own, and therefore abandoned property can become the property of whoever picks it up and decides to take ownership of it. So in that situation, with the chair left out in the trash, whoever drives by and picks it up, they can become the owner. With lost property, when it is first lost, it is still the property of the owner. They haven't given up their ownership. But as time and distance go on, it becomes less and less likelihood that the owner will be found, and then we can have what's called a constructive abandonment. So that even though I didn't intend to ever give up my lost property, by virtue of the reality of life, there's no way I'm going to get it back, and whoever finds it at that point becomes the owner. Now, different types of property fit this scenario in very different ways. If I forget my computer on the subway, and you can open it up and see my name and address and my programs in there, that almost would never become abandoned, because anybody with half a brain should be able to figure out how to get it back to me. Same thing if I drop my wallet, if I drop my credit card. Turning the credit card into the bank or the credit card company will get it back to where it's supposed to be. There's very little likelihood that that could ever be considered constructively abandoned. However, when I used to ride the subways in Boston every day, I would routinely bring an umbrella on rainy days, because both places where I lived, I had a decent walk from my house to the subway station or to the train station, and I would invariably forget my umbrella once or twice a month on the train. In those days, the MBTA folks, every night when the train got back to the train yard, people would go through to clean them. They'd pick up all the lost property. They'd drop it in the lost and found. That umbrella is still my umbrella. And if I show up at the lost and found at any time over the next few weeks and say, hey, I left a black umbrella on Riverside Train D 2 weeks ago on the 14th, the little guy could go in the room, find it, give me my umbrella back. It is still mine. However, a week goes by, 2 weeks go by, a month goes by, 3 months go by. At some point, that umbrella is lost. It's not going to get connected to me. The MBTA has the right to claim ownership of it and do whatever they can, which I presume would be throw it out at that point. However, if I drop a dollar bill out of my pocket on my way from the cafeteria back to my classroom, the constructive abandonment of that is probably seconds, because unless I've memorized the serial number, there's no way I can identify that as my property. And even if I could, if somebody picked it up and I don't see them pick it up, there's no way I can determine who picked it up and where it went. So depending on the type of property involved, constructive abandonment sometimes can never happen, sometimes can happen almost instantaneously. A word to the wise here. A thief can never become the owner of property, and a thief can never give good title. All right, so property that's stolen remains stolen always, and if the real owner can ever be found, they have the right to claim it back. And under our system, not only the original owners, but their heirs at law, their beneficiaries of their will would have the right to claim it back as well. An important thing to realize, so if you have suspicion that property could be stolen, they don't deal with it, don't have anything to do with it, back away quickly and find another transaction. During World War II, the Nazis roamed across Europe, taking Jews, imprisoning them in the concentration camps, and stealing their property. There was a case going back in the 1990s, so the war was over 1945, so 1990s are 50 years later, where a museum bought a painting from what was a reputable art dealer, and the art dealer's paintings have not titles, but they have histories that follow them, the rare and expensive works of art, and this one seemed okay. Museum spent several hundreds of thousands of dollars for this painting, brought it to the United States, and a woman happened to see either a picture of it in the paper or she happened to go to the museum and see it, and remembered she was a Holocaust survivor, and she remembered that painting hanging in her grandfather's hallway 50 years earlier in Vienna or in Berlin. She hired lawyers, and the painting was now worth millions of dollars. She hired lawyers, and they were able to establish that up until 1939, 1940, it was known that that painting had been bought by her grandfather earlier in the century, and then the painting disappeared for a number of years and reappeared after the war somewhere. She got the painting back, and the museum was out of its money. Now, I suppose they could go back after the art dealer. However, the American federal courts were very clear that that was stolen property. She had established enough evidence to prove it was stolen property, and by virtue of her and her children being the heirs of her grandfather, it was now her property, not the museum's. And no matter what they paid for it, no matter how good of a deal they thought it was, how up a deal they thought it was, it didn't matter. Once it had been proven to be stolen, it was stolen, and the law will work to return it to the rightful owner. Another way in which you can become owner of property is through something called accession. And accession is interesting. If we're out in the Midwest, you guys would know what this term meant. Here in Rhode Island, nobody does. Accession is the idea that when personal property can increase or recreate itself, the owner of the first piece of property owns all the other property. Now remember I said pets are personal property. Well, so are farm animals. So when Betsy the cow has a calf, whoever owns Betsy automatically owns the calf. It seems logically enough. I'm sure I've never had to think about it before, but the law has had to deal with questions concerning that at times, and they call that accession. The item of personal property can increase, and the owner of the first thing owns the others. Another way that you can become owner of personal property is through inheritance. When somebody dies, if they have no will, you're their heir at law, their personal property can come to you. Or if they have a will, you can be named a beneficiary. The specific name for someone named to obtain personal property is a devisee. And sometimes they'll say to devise property in a will. So that's another way. We've kind of gone over here by numbering them. We've gone over the ways that you transfer ownership of personal property, and there are basically 6. You can make a gift, you can obtain it by inheritance or devise, you can have a sale, you can have abandonment and somebody taking possession, you can have loss and constructive abandonment and someone taking possession, and you can have accession. So those are the 6 ways that ownership of personal property changes from one person to another. Now, there are different ways to prove who owns a piece of property. And again, up until very recently, in the advent of the mega computer systems, there was almost no way to track all the billions of pieces of personal property that we exchange every day around the planet. So we had to come up with some rules about how we will determine who owns personal property. For certain items, we talked about this, I believe maybe in the last lecture, maybe in the beginning of this lecture, for automobiles. Because they are very valuable, because they are very movable, the states have come up with a system where every car has a unique identification number, and the state governments will issue title certificates saying a vehicle with this number belongs to this person. That is almost conclusive evidence that you are the owner of the vehicle if your name is on that certificate. Another way to determine ownership is if you have the contract, you have the receipts, you have the bills, you have the different paperwork involved in purchasing the item. You keep it, and that is your proof of ownership. If you inherit something, there'll be records in the probate court saying that you were an heir and this is part of the estate, this is what you received. And finally, for most items of personal property in the world, the law looks at what's called peaceable possession. So there is a legal presumption. Now, I don't think we talked about presumptions yet. In the law, a presumption is something that is accepted as true until proven otherwise. So when there is a legal presumption, you don't have to prove evidence. The law takes this as true, and the other side has to bring in the evidence. Anyone who is in peaceable possession of a piece of personal property is presumed to be the owner until proven otherwise, which is why if you're walking down the hallway one day with a very nice new winter coat on worth a couple $100, and I say to the security guy, "That's my coat, get it off that student, give it back to me," the security officer, he or she knows what they're doing, will say, "I can't do that, Professor Walsh," because as long as you are peaceably in possession, minding your own business, the presumption is you own that item of personal property that you have possession of at the moment, and it is up to me making a claim against you to bring in the proof to prove that you're not. The presumption protects you. The only way I could get that item would be to bring evidence to court to show that it was really mine and that somehow you got it from me first. I think that's pretty much it for this section. I do have a number of Rhode Island statutes summarized at the bottom of this handout. We haven't gone over this yet, I don't think. Rhode Island statutes, RIGL is how they're named. It's Rhode Island general laws. They're listed as title, chapter, and section. So the first one there you see is 33/21.1/1. That's Title 33 of the general laws, Chapter 21.1 of Title 33, and Section 1 of Chapter 21.1. That is the notation system that we use for the general laws. Very helpful today. The Rhode Island general laws are on computer, free to the public. The General Assembly has a set of the general laws online. You can type in a subject matter, you can type in the section number, and the statute will pop up. Some of the Rhode Island statutes: personal property is presumed abandoned if not claimed within 3 years. You've often probably seen, every now and then, the Secretary of State will put a whole list of lost property in the newspaper. Under Rhode Island law, if you have a bank account, an insurance policy, any type of thing, and you don't touch it for 3 years, the next statute says that institution is obligated to turn it over to the state. It goes into the general treasury, but if you can prove it was yours, you have the right to at least get the value of it back. All right. What else? Personal property worth more than $50 is supposed to be turned over to the police. No one ever does. The owner then has 90 days to contact the police. No one ever does. But if you went and tried to do this, the police are probably saying, oh, we don't want that at this point in time. If the owner doesn't claim it within 90 days, the finder becomes the owner. And if it's left with the police and nobody comes back in a year, then the state takes the property. The police must turn it over to the state. All right. We're done with that section. Carry on. I will see you next working on handout 5.